Do you owe this amount, Mr. Counsel?
I don't know. I know I don't owe that amount.
Look at me, please. Wait. Look at me, please.
I'm at work right now. Yeah, I'm at work, kind of watching my surroundings. I'm at work. I'm a truck driver. Yeah.
You're not driving, right?
No. I'm parked at the dock, but I gotta keep an eye on this light. Yeah, I'm sorry. Go on. I'll try to keep it out. Look in the mirror.
Are you driving?
No. Look, I'm sitting in the parking lot.
Well, then what's prohibiting you from looking at me? Just look at me. I'm just asking you, do you owe this debt?
No, I did. I know it wasn't that much. I don't know if they put.
How much was it?
Can't remember, sir.
Well, then how do you know it wasn't that amount? Listen to me very carefully. Mr. Counsel. It wasn't that amount. Mr. Counsel, look at me, sir. You're looking ahead. I want you to look at me.
Their plaintiff or defendant. Look, first of all, I'd like to say, it doesn't appear that the defendant is present and he has a non-attorney individual.
Timothy Holloman, not Robert Holloman. Who's here? Is Timothy Holloman here?
No, he's not. I'm Robert Holman, his father, acting on his behalf with I guess, permission with a power of attorney.
I can't let you appear, sir. I cannot let you represent him in the courtroom here. I can't.
Okay.
I'm sorry, Your Honor.
When I read through the power of attorney, it gave me those privileges.
Yeah, you don't have to. I'm sorry. I cannot allow a non-attorney to appear.
Okay.
Now, you might have the power, I'm sure you do, if you're telling me accurately, to go hire the lawyer on his behalf. But I cannot let either he has to appear or you have to appear. I'm not quite sure. It says the funds or property are exempt from garnishment by law. And then it says the writ was not properly addressed or is otherwise invalid because there's improper service to an incorrect address. Jennifer, I don't have any response from the plaintiff here.
Judge, let me look in the file. I was out of the office on Thursday and Friday, so if it came in,
You're going to have. I don't want to make people come back if this is invalid. I'll let you go hire a lawyer. Let me just put it to you that way, Mr. Holman. I can give you a week or two adjournment, and you can go get a lawyer.
Okay.
Where was this served at, Ms. Faze?
It was e-filed on Wednesday.
You're talking about your response. I'm talking about the writ. Did you file a response?
they did, Your Honor. They filed a response on the 8th on Wednesday. I was out of the office, so it didn't get attached.
Would you please bring that down?
I'm printing it now.
Okay. I'm going to go on to another case. I'm going to ask you two to stand by and let me take a quick look at that, please. LBNV versus Sandal Taylor, file number 2504738. Okay,
Yeah.
Everybody's name, please.
I'm
Good morning,
Sandal
Your Honor.
Taylor. Go ahead.
And Olivier, appearing on behalf of plaintiff.
All
I'm
right.
Sandal Taylor.
I didn't receive anything from you, ma'am.
I called yesterday. She said she received it on the 7th.
Judge, I'm printing that as well. It's a one-page document she filed. It's not.
And plaintiff filed its reply brief the next day on the 8th.
All right.
And we can adjourn this. Defendant said that she didn't get her
Now,
copy.
let me take a quick peek at those, okay? We're going to have to figure out a way to handle that better, though, Jen. LVNV versus
Sorry, Judge,
I understand. We'll talk about it. LVNV versus Hancock, Brian T. Hancock, 2600624GC. The parties here on LVNV versus Hancock.
Your Honor, and which case are you calling, Your Honor?
LVNV versus Brian T. Hancock.
Okay, Your Honor, I have not had either party check in on that one, neither attorney.
I'm glad I was gone for a week. This is how things are going to start out today, huh? Okay, Jefferson Capital versus Joe Tostage, 2600218. Is anybody here on that? John, can you turn the thermostat down, please? Sure. Is anybody here today besides?
Your Honor, both, I'm here with defendant on Synchrony versus counsel.
Synchrony Bing versus Mark Counsel, 2601656.
Good morning, Your Honor. Jay Bagg, P36820 on behalf of plaintiff.
Mr. Counsel, you're going to state your name and I'm going to ask you to take your hat off, please.
What
Mr.
you say?
Counsel,
I'm sorry. Yes.
okay, stay with me now. I need to see your face. I'm looking at the ceiling. There you go. Tell me your name, please.
Mark Counsel.
Did you guys talk about this, Mr. Bagg?
Yes, at this time, we're unable to settle it. If we can just get a scheduling order with some discovery, that would be great.
You owe this amount, Mr. Counsel?
I don't know. I know I don't owe that amount.
Look at me, please. Wait. Look at me, please.
I'm at work right now. Yeah, I'm at work, kind of watching my surroundings. I'm at work. I'm a truck driver. Yeah.
You're not driving, right?
No. I'm parked at the dock, but I gotta keep an
Sir?
eye on this light. Yeah, I'm sorry. Go on. I'll try to say, keep it out. Look at the mirror.
Are you driving?
No. Look, I'm sitting in the parking lot.
Well, then what's prohibiting you from looking at me? Just look at me.
Okay, yeah. I can't even see you, to be honest.
Mr. Counsel, listen to me. They think that you owe $4,269.87. Your answer to complaint is, I want to settle out of court. Sincerely, Mark Counsel. I'm just asking you, do you owe this debt?
No, I did. I know it wasn't that much. I don't know if they put.
How much was it?
Can't remember, sir.
Well, then how do you know it wasn't that amount? Listen to me very carefully. Mr.
It
Counsel.
wasn't that amount.
Mr. Counsel, look at me,
Yes.
sir. You're looking ahead. I want you to look at me.
Okay, sir, I'm a truck driver, but okay. I got to watch my surroundings, make sure nobody tear up my stuff. I got a lot of people just driving back and forth around here. Okay, but go on. I'm sorry. I'm working like you are.
Listen, I'll tell you what I'm going to do. Mr. Bagg, I'm adjourning the pretrial. Defendant to appear in person. I don't need you getting smart with me, Mr. Counsel. You're
I'm not
working
getting
like
smart
I
with
am.
you.
Really? Counsel, I think you should just file your motion. You do what you want. I'll set it for pretrial in 2 weeks. I'll set for
Thank you.
pretrial in 2 weeks at 8:30, defendant to appear in person. What date is that going to be? The
The
27th?
27th, Your Honor.
You have to be
Yeah,
in person December 27th
So,
of 26 at 8:30 in the
Yeah.
morning. If you don't show
Yeah,
up, I'm going to default you. Have a good day. Thank you.
Yeah.
Shut
Thank
them
you, Your
off.
Honor.
I'm not in the mood to hear this nonsense this morning. Granite Valley versus Ronald Allen Bodges, 2600001.
Garrett Levine for the plaintiff.
Okay, I need you to,
Okay.
there you go.
Good morning.
All right.
Your Honor, we did writ him out of Wayne County. I've not had the county log in yet.
I don't know what to tell you. Why don't you just do whatever else you got to do, Mr. Levine, and mute us, and when they come in, I'll call them, okay?
I have a 9:30 pretrial with you. I think it's with you. So
But you can just check back in. Well, I don't want to keep the county waiting if they're putting them in front of the camera there.
I'll be
So-
ready for you.
So just mute us. Okay, thank you. Orbit Leasing versus Preston Rose, 2601249.
Good morning, Your Honor. Matthew Kuipers on behalf of the plaintiff.
Is Preston Rose here?
Yes, I'm here, Preston Rose.
Your name?
Preston Rose.
Did you two talk, Mr.
We have, Your Honor. There's settlement discussions ongoing. At this point, I'm just requesting 60 days of discovery and time for motions if needed, but I'm pretty sure this is going to get resolved before then.
All right, just give me 1 second. And Mr. Kuipers, it's Matt Kuipers. Kuipers, and your P number is 71348.
That's correct. And I'm filling in for the attorney of record, Jeremy Chisholm.
All right, I'm going to give you until September the 15th of 26 to conduct discovery. Witness lists are due on August the 15th. I'm putting down 1/2 hour for trial. You don't have to file a trial brief. If you choose to, it has to be filed and exchanged not later than 27 days before the trial date. All motions and responses. I don't want witness lists. I don't want that kind of thing, but anything that's a motion or response to a motion, I'll need a second copy, marked judge's copy. We're going to give you a trial date. All motions for summary have to be filed and heard not later than 20 days before the trial date. Why don't you give me one, Jennifer, for the latter part of October?
October 20th at 10:30.
At 10:30, okay? So that'll be, I'll send out the pretrial order. And you should have that, I would think, by Thursday or Friday, okay? Anything else,
Thank you,
Mr.
Judge.
Kuipers?
Nothing on this matter, Your Honor. I do have a 9 o'clock for Capital One and Brandy Regan.
Okay, let me see if I can pull that out. Any questions, Mr. Rose? So if, I'm gonna let you conduct discovery. If you think they have documentation or any other item that will help prove that you don't owe all or part of this debt, then you can request it in writing from them. Okay, sir? So you have a couple months to do that. And I wish you well. I'd encourage the two of you to continue talking. It's okay? Any
Thank you.
questions, Mr. Rose?
No, sir.
All right, good luck. Thank you.
Your Honor, if I may, there was a Samsung device.
Samsung device, I need you to identify yourself. We have no clue who you are. SM5F9 is on the screen. Samsung SM5 or F9. You have to identify yourself. Samsung SM F9, you have to identify yourself. You have to start your video and tell us who you are.
Judge, I've tried taking them to a breakout room as well in order to identify them. I'm going to go ahead and remove them.
Thank you. LVNV versus Myron Covington. 2601895.
Yes, good morning, Your Honor.
Good morning, Your
name,
Honor.
Mr. Okay, Ms. Law, good morning. Your name?
Attorney Brittany Law, P83917, appearing on behalf of plaintiff.
And Mr. Covington, your name?
Myron Covington II, sir.
All right, did you two talk, Ms. Law?
We did, Your Honor, and we reached an agreement in this matter.
Good. Tell me what it is.
The defendant has agreed to pay a reduced balance of $2,400 over 24 months of $100 a month, and that will begin August 14th of this year and be due on the 14th of each month thereafter.
And is the total judgment amount going to be for $2,400 even if he doesn't pay? In other words, you get credit for any payments, but if, let's say he makes 4 payments, are you saying it's then going to be reduced to $2,000?
Correct. We did talk, if he misses a payment, it will go back to the original amount of $2,978.
And is this in the form of a consent judgment or conditional dismissal?
Consent judgment.
So, sir, do you understand what Ms. Law just told me?
Yes, Your Honor.
She tells me that you've agreed to pay $2,400 with the understanding you'll pay $100 per month. A judgment will enter in that amount commencing August 14th and the 14th of every month thereafter until paid in full. So long as you make those payments, the balance will remain $2,400 less any payments received. So if you pay them all, that's it. You'll be done in 2 years. If you miss a payment, then the judgment amount, they're going to file an affidavit of noncompliance, and the judgment amount will reflect the balance of $2,978 less any other payments that you made. Do you understand that?
Yes, Your Honor.
Do you agree to those terms?
Yes, Your Honor.
And does Ms. Law have your permission to sign your name to this proposed consent judgment?
Yes, Your Honor.
Any questions at all, Mr. Covington?
No, sir.
All right, you are all set. Thank you very much. Good luck.
Thank you.
Thank you.
All right, you too. Thanks.
Midland Credit versus Lynette Cloud, 2601416. John, they brought some paperwork here. I told them to put up here. Let me see what you just grabbed. That one you can take. Yeah. All right. Do I have anybody on Midland Credit versus Cloud?
No, Your Honor.
This is going to be called Chase a Lawyer Day again, huh? What was the other case that you didn't have anybody check in?
LBNB versus Hancock. It's an SD motion.
Have somebody call them each. If nobody answers and nobody shows, I'm simply going to dismiss the case. Jeff, Stamson Billy Alohi versus Sucre Singh and Michigan Truck Driving School, Inc., 2601776R. Anybody here on that?
I don't have anyone on Zoom, Your Honor.
At what point am I going to just start dismissing cases? That's the question. Man, I don't understand this. Did I call Orbit Leasing versus Preston Rose yet? What happened with that? Nobody here again on that?
No, that was for the pretrial.
Oh, yeah. So that was, okay, my fault. All right. All right. This is SoFi Lending versus Timothy Hallman, 18R2629. John, you had that done.
Good morning. Again, Your Honor, Andrea Faze for the plaintiff, P76952.
Okay. And Mr.
That should have been, and I think it's that one right there, the binder.
Oh, thank you. Mr. Hallman, your name?
Robert Holman.
I'm going to have you take this. You're going to have to get a lawyer. How long will it take you to get that for your son? Here you go.
At least a week.
I'll adjourn it. Let me give you 3 weeks. We'll adjourn this 3 weeks. And you can make sure you get a lawyer here. Oh, I'm not going to be here that day, am I? Yeah, yeah. Adjourn 3 weeks to what would that be? The 3rd?
Yes, Your Honor. I was going to ask you actually if we could add an afternoon that week. So could we do it at 1 o'clock on that Monday, the 3rd?
Yeah.
Okay.
What do I have in the morning? I can't do in the morning.
probation and department reps.
August 3rd at 1 o'clock, we'll do this, okay? I'll have the motion heard, but you have to bring a lawyer, Mr. Coleman, okay?
Yeah, very good, Your Honor.
All right. Anything
Oh.
else that anybody needs to bring up before I set this aside?
I'm not from plaintiff, Your Honor. Thank you.
No, Your Honor.
All right, we'll see you guys on August the 3rd at 1 o'clock. Thank you very much. Have a great day.
You too.
You too.
All right. Is anybody here that has a case, right? Anybody where I don't have to call lawyers or have the staff call lawyers?
Your Honor, Mr. Kuipers is here on Brandy Reagan. They're ready.
We're ready.
Which one?
Capital One versus Reagan. 1617 is the case number.
Capital One versus Brandy Reagan, 2601617.
Good morning again, Your Honor. Matthew Kuipers on behalf of the plaintiff, P71348.
Ms. Reagan, you have to unmute and tell me your name, please.
My name is Brandy Regan.
Did you two talk and try to resolve this?
We did, Your Honor. Same situation. Settlement discussions are still ongoing. Plaintiff's just requesting 60 days discovery and time for motions, but I'm hoping this will get resolved before motion is filed.
So, great. All right, so this is what I'm going to do, Ms. Reagan. I'm going to give you the same dates that I gave on the last one, and you can correct me if I'm wrong on any of these dates, Jennifer. September 15th will be the discovery cutoff. Witness list, I'm sorry, September 15th will be the discovery cutoff. There's no jury demand. There will be no settlement conference. Witness lists are due on August the 15th. You have to file a witness list, Ms. Reagan. You don't have to file a trial brief if you choose to. You have to file and exchange it not later than 20 days before the trial. I'm sorry, 7 days before the trial date. No motions will be heard on the date of trial. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. Okay. Let's see. What did you give me again as a trial date on these, Jennifer? October
20th, correct. At 10:30.
Perfect. So I will send these out. Ma'am, I want to know if you have any questions for me at all. Discovery is the exchange of information. If they have documentation that you think will show that you don't owe any of the debt or not as much of the debt as they claim, you can request those documents in writing. You could send them written questions called interrogatories if you so choose, okay?
Okay.
And I'd encourage you too to keep talking. Do you have any questions for me, ma'am?
Yeah, you said that I'd have to file a witness.
A witness list disclosing the names of all your witnesses by August the 15th.
Okay.
If you have witnesses, you might not have witnesses.
Okay, just myself.
Okay. But that's all I can say about that.
Okay.
If you have any other witnesses, you need to add them on that witness list too, okay?
Okay.
Anything else, Mr. Kuipers? Here you go.
No, that's it, Your Honor. Thank you.
You guys have a great day. Good luck to you, Ms. Reagan, CD.
Thank you.
Thank you. Capital. Oh,
Your Honor, on the LVNV versus Hancock, Miss Law is going to handle that one. I just have to get a call into Mr. Strauss's office now.
you guys didn't resolve this, Ms. Law? Why are lawyers not showing up?
I'm sorry, Your Honor, I'm trying to look into that. It wasn't on our calendar for today.
Well, it was on everybody's calendar for today. But what time did we have it scheduled, Jennifer? I just don't understand. If I got out here an hour and a half late, they'd be complaining about me. But lawyers showing up more and more late like this, it's just disturbing to me. It's like, how far are we gonna go? How sloppy are we gonna be?
Your Honor, we had it for 8:30 this morning.
Yeah,
Sorry, I
so
was
he's
leaving
not
Mr.
here, it's
Strauss a message.
9:25. I mean, if you want to hear your motion, ma'am, I'll be glad, Ms. Law, I'll be glad to hear it. I'm just not going to have us chase people around anymore. We're not babysitters over here. You want to argue it? Well, I'll tell you what, you can call him, tell him if he doesn't log in by 9:30, I'm hearing your motion. Okay, thanks. Christian
Thank you, Your Honor.
Financial versus Austin Ortega, 2503014.
Good morning, Your Honor.
Good morning. Your appearance?
Elizabeth Butler, P80956 for plaintiff.
Where's Austin Ortega? Do you know?
He did
Your
not
Honor.
appear.
He didn't, did he send you the items?
Only some of them, Your Honor, and I received them yesterday afternoon. I looked at them, still do not have everything we need. We were here on June 29th, and you generously gave him until today just to send us the documents so we could cancel this hearing, and he emailed us that he does not intend to appear. He didn't give me everything. I would ask that the court consider a motion for bench warrant. He knows he's supposed to be here.
You know what? I usually require a show cause, but you know what? He was here. He didn't bring what he was supposed to bring. He was going to send it to you. He knew the hearing date. I agree with you. I'll issue a bench warrant. How much do you want? What is the amount of the judgment here again?
For today, it's $6,787.60.
Bench warrant to issue $2,000, okay? 2,000 cash. You can
Understood.
submit that. I'll make it 2,500. That's just not right. We ignored court orders. That's what I'll do. Thank you very much.
Thank you,
And for
Judge.
the
You and your
record-
clerk have a good day.
And for the record, I'm sorry, give me 1 second here. This was scheduled for
9
What-
o'clock, Your Honor.
9
Right.
o'clock?
Yes,
Yeah,
Your Honor.
9, now 9:27. Thank you. Have a good day.
Thank you. You too.
Samsung device, can I get your name, please, or I'm going to disconnect you? Judge, on the LV, or I'm sorry, Midland versus Cloud, I have left a message for plaintiff's counsel on that one as well.
Which one?
Midland Funding versus Lynette Cloud. No one appeared, neither party, and I did leave a message for plaintiff's counsel on that one as well.
What's happening? What's happening? It really, I guess I should just start dismissing cases. Maybe people will learn.
Your Honor, we have Teresa Roberts and Brookston escaping in the courtroom.
LVNV versus Teresa Roberts. 2601897.
Good morning, Your Honor. Attorney Brittany Law, P83917, appearing on behalf of plaintiff.
Ma'am, your name? Did we just adjourn this for another pretrial or something?
We did, Your Honor, but the defendant has paid this in full. We are sending in a stipulated dismissal this afternoon.
Okay, so you're dismissing the case with prejudice.
Correct.
Okay, is that, you understand that?
Yes.
And she has your permission to sign your name to this case, the stipulation that will dismiss the case with prejudice, meaning that they can't bring the action again arising out of this event transaction occurrence. You understand that?
They did send me a letter and then I sent it back, but they didn't get it in time to dismiss for today.
Okay, well, you're
Correct.
gonna send, you're gonna
We
send
just
it
got
in.
her signed one this morning.
I see. Okay, so send that over. I'll just make a note. Defendant was here. plaintiff attorney here. Case dismissed with prejudice. I'll sign the order when it gets here. Have a good day. Do you have any questions, ma'am?
Thank you.
Good. You don't have to thank me. Good luck. Thanks,
you.
Ms. Law.
Thank
All
you, Your
right,
Honor.
so now I also have, I'm calling LVNV versus, Brian Hancock, 2600624. Ms. Law, did you call Mr. Strauss?
Yes, Your Honor, I haven't had a chance to reach his office, but we do have a consent judgment on this one.
Oh, well, that's different. You guys both signed it?
I have not received a signed copy back from him quite yet. It looks like we sent it 2 days ago.
Adjourned to July 27th. I'm sure we'll have it by then, right?
Yes,
We'll
we
adjourn
should.
this to July 27th at 8:30, and then I will go ahead and sign the order. Thank you very much. Do you have
Thank you, Your
another
Honor.
one?
That is all I have on my calendar.
Have a good day. Thank you. All
You
right.
too.
Now I'm going to move on to Bingo. Where's that? That paper's all over the place here. LVNV versus Sandal Taylor, 2504-738. Okay. Appearances, please.
Good morning again, Your Honor. Lynn Olivier, appearing on behalf of plaintiff.
And Ms. Taylor, your name, ma'am?
Sandal Taylor.
So this is your motion. And you can go ahead and argue it.
Hi, this is plaintiff's
Lord-
motion for summary disposition. Your Honor, you should have in front of you both the answer to plaintiff's motion that defendant filed last week. And do you also have plaintiff's reply brief to her response?
Right.
Okay. So
So-
the last time we were here, we started plaintiff's motion for summary disposition. She admitted that she did have a credit card with Credit One Bank, which is the underlying credit card for this matter, Your Honor. You had ordered the defendant to file an answer to plaintiff's motion, and she did. And she lists 3 arguments. The first one is that she failed to include required disclosures. The plaintiff has failed to include required disclosures. Plaintiff does not know what disclosures she is talking about. She never articulated anything, so plaintiff is unable to respond to that, as plaintiff will not speculate as to what the defendant means. Secondly, defendant states that plaintiff used unlawful debt collection practices. Again, she doesn't articulate what she's means by that, and plaintiff will not speculate on that either.
I can
And for her
speculate
final-
today. I can tell you what I mean today.
And for her final argument, she says
Talking,
that
Ms.
there's no,
Taylor. She's still talking.
I'm
that
sorry,
there's
Your
no
Honor.
I said she is still talking. Don't interrupt her.
Go right ahead.
Go ahead.
She, for her final argument, says there's no proof of ownership. That is incorrect. Plaintiff did provide the bills of sale. Defendant, however, is a non-party to the assignment, and she lacks standing to challenge the validity of the assignments. But plaintiff did show that each bill of sale is signed by the respective party to be charged, i.e. by an authorized representative of the entity that is transferring their accounts. And further, each bill of sale contains language to the effect that it is transferring, assigning, granting, or otherwise conveying accounts to the entity that is purchasing the accounts. And this type of language creates a valid assignment under Michigan law. Plaintiff therefore has valid proof that it is the owner of defendant's debt. Thus, defendant's final attempt to create an issue of fact in an attempt to evade liability for a debt that defendant does not deny incurring must fail. And plaintiff requests that its motion for summary disposition be granted at this time, and then judgment be entered for plaintiff and against defendant for the full amount paid
Ms. Taylor, this is basically a letter. I adjourned it last time when you told me you didn't receive the motion. I gave you another opportunity. This is a letter. And it's not, I understand that you're representing yourself,
Correct.
but you still, there's still a smidgen of rules that you have to comply with, and you don't comply with anything here. There's no counter affidavit. There's no documentation that you have attached to anything here that creates a material issue of fact. I mean, there is no genuine issue as to any material fact. I'll let you say whatever you'd like to say for the record, but and you can feel free to tell me why I shouldn't enter judgment, but
Your Honor, the plaintiff has failed to give me original documentation that's signed. According to the Fair Debt Credit Practices Act, they are using misleading information to get money from defendants. They haven't given me anything stating that I have a signed original contract with the creditor. There's nothing. They have not given me that.
anything else that
I
you
don't
want
have
to say? Sorry.
I believe that they have not given me an original signed credit agreement. The original contract, they have not given me that, stating they can't prove to me that they own this debt, Your Honor.
Okay. Anything else, Ms. Olivia?
No, Your Honor, plaintiff rests on its pleadings.
Defendant has failed to raise. First of all, I have to take all the evidence in the light most favorable to the non-moving party here, but even saying that with a letter basically that's 3 lines addressing the case, or I guess 4.5 lines, there's nothing that creates a genuine issue as to any material fact. The court finds there is no issue, no genuine issue as to any material fact, and will enter judgment in favor of the plaintiff. You have 8004 in terms of the principal amount. What kind of motion fees and costs do you have?
Costs of $111.02, plus a statutory $20 attorney fee, for a total judgment amount of $1,111.06.
You said 11107, didn't you, in costs?
111.02.
11102. And you're saying $20 statutory attorney fee. You said this to me last time. I don't know why they're only adding in 20 instead of 75, but they're entitled to 75. But if you want to limit it to 20 again, that's fine. That's 13102. So do I have $1,111.02? Is that the total amount you're asking for?
6 cents, 1111.06.
Where's the other 4 cents come from? I thought you said 02 on the cost, 111.02.
The damages are $980.04.
You're right. My apologies. I thought it was, you're right. Thank you. So it's 111106. You submit your judgment, and I wish you well, ma'am. Good luck to you. Thank you.
Thank you. Have a good day, Your Honor.
You too. Thanks.
Thanks.
Tom Parisi versus Brooks Landscaping. Are we ready on that one, or do I have another quicker one here to go through?
Your Honor, this one will be quick. Mr. Parisi did not appear. Mr. Parisi contacted the court this morning, says he has no mode or means of transportation to the courthouse, so therefore he could not get here. He was requesting an adjournment. I told them that would be up to the court on whether or not it would be adjourned.
He only
has
lives
had the
in
date for 30
Brownstown,
days.
right?
Yes.
I mean, like,
He says he's disabled and cannot get here, but he doesn't have the ability to Zoom either, because I did ask that question.
your name?
Daniel Brooks.
I mean, he had to figure out a way. How did he get here and get the paperwork filed, you know?
He mailed it in, Your Honor.
Well, he had to figure out between that time, which was back in June, the early first week of June,
Yeah.
and now.
Yeah, he had about 30 days.
I mean, if he can't use Zoom and he can't get here, I don't know what I can do for him. I'm sorry, he can file a motion to set aside the dismissal, and I feel bad, but, you know, he got to show up somehow. He could have, I don't know how badly disabled. I feel badly for him, but Either got to learn how to Zoom or get here. I'm going to dismiss the case. You're all set. Thank you.
Thank you.
How about Samson Billy, Alohi versus Sakral Singh in Michigan Truck Driving School, Inc., 2601776R.
Your Honor, Mr. Alohi was the Samsung that we could not get connection with. He called the court. He's on his way here, but the defendants have not checked in with me.
Were they served properly?
This was a removal from small claims to general civil. And I believe it was removed by the defendants.
Well, but I'm going to end up giving them a judgment if they don't show up. I'm going to give the plaintiff a judgment. Rogers is not checked in, right? Do I have Midland Credit versus Cloud? Lynette Cloud, 2601416. Is anybody here on that one?
No, Your Honor, I left a message with plaintiff. Oh, I'm sorry.
My name is Philippe Cicchini. I'm here on behalf of Midland Credit, but I'm here for Lisa Robertson and Ladero Garner. I don't have I don't have the notice to appear for the one that you're calling right now, but I'm here. So if the defendant's here, I'd be happy to speak with he or she in a breakout room if that's allowable. But
what was this up for, Jen?
Your Honor, I'm pulling it back up. It just says hearing.
It was a hearing regarding
was this regarding the alternate service request? Because they were requesting non-tacking.
Yeah, I require three things, and one of which is tacking. Mr. Cicchini?
Yes, sir.
So that was a problem. That's why I set it for hearing. I'm not going to just let you mail by first class and certified mail. You're also going to have to tag. So I've been doing that for decades.
I understand, Your Honor. This is the first I'm hearing about this case this morning. Like I said, I'm here to appear for two other ones. So if someone can provide me the case number, meanwhile,
it's 2601416. 2601416.
Okay.
So you can look that up. Are you here on Garner?
Yes, sir.
Midland Credit versus Ladero K. Garner, 2600458.
Good morning, Your Honor. Philippe Cicchini on behalf of the plaintiff Midland Credit.
Mr. Garner, good morning, sir. Your name?
Good morning, Your Honor. My name is Ladero Garner.
Good morning to you. Did you two talk, Mr. Cicchini?
Yes, we did, Your Honor.
Any resolution?
Not today, Your Honor, unfortunately.
All right. I'm going to do the same thing on this one. September 15 is discovery cutoff. September 15 is discovery cutoff.
Okay.
And you have one L there or two. It looks like two L's in your name, right, sir?
Are you speaking with me, Your Honor, sir?
Yes.
So Philippe, Philippe. So one L in my first name, if that's what you're referring to.
My eyes are going on me, among other things. And that's 69928, right?
Yes, sir. 69928.
All right. So, Mr. Garner, do you owe this debt, sir?
No.
Okay. I'm going to give everybody discovery until September 15th. There will be no jury trial. Nobody made a jury demand. Witness list due August the 15th. No settlement conference.
I didn't see theft.
I'm sorry?
I didn't see theft. Good morning, Your Honor. My name is Ladero Garner. I respectfully dispute the plaintiff's claim. I believe this account is I
So,
believe,
sir, what I'm going to do is I'm going to give you court dates and cutoff dates. You have to file a witness list disclosing the names of all your witnesses by August 15th. You have to file a discovery cutoff, which is the exchange of information. If you think they have something that you think will aid in your defense of the case, you can make a written request for it. If you want to send them written questions, interrogatories, you can do that. I'm giving you guys until September 15th to conduct discovery. I'm giving you guys until August 15th to file your witness list. We're going to set a trial date on October the 20th at 10:30 a.m. You do not have to file a trial brief, but if you choose to file one, it has to be filed and exchanged, not later than 7 days before the trial date, and all motions for summary disposition have to be filed and heard, not later than 20 days before the trial date, okay?
okay,
Do you have any questions for me, sir?
no, I don't.
I wish you well, sir. Good luck. Anything else, Mr. Cicchini?
Not on this one, Your Honor.
Have a great day. Thank you. Here you go. Save you. All right, Jefferson Capital versus Cassie Harbison, 2601006.
Good morning, Your Honor. Mimi Kalish. My P number is 52383 on behalf of the plaintiff.
Good morning, Ms. Kalish. Ms. Harbison, can you tell me your name, please?
It's Cassie Harbison.
Okay. This is simply a pre-trial, right?
It's a date and time for a motion for summary disposition, Your Honor. Let me make sure of that. Yes, it is.
I don't think I have that, Jennifer. Did you file a response, Ms. Harbison?
No, not this last time. I only did the first court date. I don't think I understood that I was supposed to.
Do you agree that you owe this debt?
Yeah, I never said I didn't. Yeah, I do.
Okay. So you can just give me a little bit of background here, Ms. Kalish, and I'll be happy to.
Sure, Your Honor. This case originated with Comenity Bank. It was a K Jewelers credit card account. The amount in dispute is $2,472.32 plus court costs and a statutory attorney fee. It's brought under MCR 2.116, C9 and or C10. It's plaintiff's position that Ms. Harbison has not put forth a valid defense, nor are there any material facts at issue for the court to decide. We're asking the court to make a decision as a matter of law and to enter a judgment accordingly. As I said, the principal balance is 247232. Court costs are in the amount of $151.48.
And does that include your statutory attorney fee?
It does not. I'm not seeing the statutory attorney fee, and sometimes that's in accordance with the client guideline. It doesn't appear that this Jefferson Capital allows for the statutory attorney fee. I am getting a total proposed judgment in the amount of $2,623.80. And if the court needs me to break down the court costs, I can do that.
No, I don't. Ma'am, do you have anything you want to say? You agree that you owe that amount?
Yeah.
Court is going to find there's no genuine issue as to any material fact. Judgment will enter in favor of the plaintiff and against defendant. 2,623.80 is the total amount, and you can submit your judgment. And I hope you'll work out a payment arrangement with them, Ms. Harbison, so they're not garnishing wages and everything.
Yep.
Good luck to you both. Thank you very much. Have a great day.
Thank
Do
you,
you have another one in
Judge.
front of me by chance, Ms. Kalish?
I don't have any more today. Thank you, Your Honor.
Have a good day. Thanks.
You too. Thanks.
Good luck, Ms. Harbison.
Thank you.
Midland Credit versus Lisa Robertson, 2601444.
Good morning, Your Honor. Philippe Cicchini again on behalf of Midland Credit.
Your name, ma'am?
Lisa Robertson.
Any resolution on this one, Mr. Cicchini?
Yes, Your Honor. The defendant and I had an opportunity to speak in the breakout room this morning, and we have reached a resolution for this one. If you'd like, we can put it on the record. The defendant has agreed to pay the debt owed of $1,267.34. She has agreed to make payments of $25 per month beginning on August 1st, to be revisited in 1 year to see if the payments can be augmented. And the defendant has given me permission to sign on her behalf, Your Honor.
It's in the form of a consent judgment, true?
Yes, Your Honor. I apologize. Yes, in the
That's
form of a
okay.
consent
Ma'am,
judgment.
do you
Yes,
agree
yes,
to that, those terms?
Yes, sir.
So you agree that you owe 1,267.34, and you are agreeing to pay these at the rate of $25 per month beginning August 1st of 26, correct?
Yes, sir.
And also with the understanding that that installment payment order, you got it worded, counsel, correct me if I'm wrong, that the installment payment order may be reviewed on motion of either party on or after August 1st of 27. Is that correct?
Correct, Your Honor.
You do?
Yes.
Okay, perfect. Any questions, ma'am?
No, sir.
And does Mr. Ciccini have your permission to sign your name again to that proposed consent judgment?
Yes, sir.
All right, you are all set. I sincerely wish you well. Good luck. Thank you very much. Have a good day.
You too, sir. Thank you.
Thanks. Jasmine Owens, have a good day, counselor. Or do you have another one?
Your Honor, I guess I'm just trying to get information from my paralegals regarding the cloud case. I just have an update on the information we received from the process server. So I don't know if you'd like to recall that one. I'm looking at it right now in real time. I'd be reading to you as the first time I'm seeing it. So if you give me a moment, if you want to call a case and come back
Take
to me,
your time. Take your time. I'll go on to another case. Jasmine Owens versus Fountain West, 2601734R. Anybody here for Fountain West, Jen?
Yes, Your Honor. Mr. Levine is here as well as a representative from Fountain West.
Okay, Mr. Levine, you're representing Fountain West, correct?
Correct.
Your name, ma'am?
Jazz.
All right. So this is just a pretrial. Did you two talk?
No.
No.
I'm going to go ahead and set it for discovery cutoff dates and witness list due dates and that type of thing. Okay, ma'am? So here's what I'm going to do. And you can feel free to talk to Mr. Levine at any time about the case and see if you can resolve it. Discovery is permitted. It's to be completed by September the 15th of 26. No motions will be heard on the date of trial. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. Nobody demanded a jury trial. You do have to file a witness list disclosing the names of all your witnesses by August the 15th. I'm putting down a 1/2 hour for trial. There will be no settlement conference date. You do not have to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial date. The trial date will be on October the 20th of 26, and that'll be at 10:30 a.m. Do you have any questions? You understand what I mean by discovery? If they have documentation that you think you would like that will bolster or help your case, you can request it in writing.
Everything today, I'm thinking that I was going to do that today, but I have to wait.
Well, this is just a pretrial. And you have the right to conduct discovery now. What I'm doing is for 60 days. So you guys can exchange information. And if they have an objection, they'll tell you. But I suggest you call Mr. Levine. You're saying that the apartment was in an unsanitary and uninhabitable condition?
Yes,
Let me see. Do you have your photographs?
I had to flash drive the video, and I gave you guys photos. Leaving April.
Did you check into this, Mr. Levine?
Yes, I did. And she never took possession of the apartment. And my understanding is she was planning on moving in with another unauthorized occupant. When that came up, that's when all these issues arose. So these are move-in costs. She never took possession of the apartment. At issue is whether or not she would owe these move-in costs. We believe she does. And if she believes she doesn't, then I think that is a triable issue for Your Honor.
Well, you didn't file a counterclaim, did you?
No, just an answer.
Okay. All right. Look, I'll just set these dates. You guys can talk. And if it's not resolved, we'll simply have our trial on October the 15th at 10:30. Okay?
October the
the-
15th at 10:30.
Anything else, ma'am? Here you go.
October 20th.
Yeah,
What did I
October
say?
20th.
What did I say? I'm sorry.
You're switching it up on us.
October the 20th at 10:30. It
Thank
was
you.
off a week. I'm a little rusty today.
20th, 10:30. Got it.
Have a good day. Thanks. And I'm going to call your Bodges case as soon as he gets here.
Well, it's an
We've got
8:30
an-
case, and I've got some time. I got court. So. how long
Jen,
am I
did
gonna
you
go?
say something?
Yes, Judge, Lisa has emailed the jail because we were questioning why he hadn't been logged in yet. So we're waiting for a response.
An 8:30 case, Your Honor, and I've got court and if you'll allow me to go on mute, and I'll come back when I can. But this is
Come on. Yeah, go ahead and do what you got to do. I mean, I don't know why.
it's an 8:30 case involving allegations where the defendant beat up his neighbor with a baseball bat. It was filed in January. I think we've had hearings going back since February, March, April, May, June. Now he's in jail probably for a good reason. It might be appropriate, Your Honor, that we enter a default judgment. But
Well, how can I do that?
No answer's been filed. No attorneys appeared for the defendant. The defendant's not present.
Second.
Been written to be.
Hang on a second. I've taken the position, I can't remember who was appearing from your office. I believe it was Mr. Landman.
Mr.
Am I
Landman's
right?
Mr. Landman's on personal leave right now, but yes. he was.
Okay. Well, that's fine. I hope everything's okay with him. He's a good man. But the fact is that I was the one who said we cannot proceed on a termination of tenancy case when somebody would be incriminating themselves. I cannot proceed to a trial and have lawyers peppering questions at him when when the incident that's
I'm not asking for a
the
trial.
both is the felonious assault issue. And he's in custody and this jail screwed up. Again, I believe this is the second time. Am I right or wrong, Jennifer?
Your Honor, this is the first time I've attempted to write him out. Last time we were unaware he was in jail.
I feel for you. I feel for you.
I'm not asking for a trial. I'm just asking for a default judgment. And
well, he's in custody. How can I do that? That's not fair.
Notice was sent, but Your Honor, it's not fair that his neighbor got beaten in the head with a baseball bat and was hospitalized.
Listen, it might be.
The other neighbors have. It's less of an issue because he's in jail, but at some point, I think we do need to entertain a default judgment. If you want me to wait for the jail, I can wait, but I need to get to another one. So if I could come back.
But listen, Mr. Levine, I don't know when the trial is scheduled. I'm not going to go forward or make him go forward before the criminal trial. I'm just not going to do it. I understand your frustration. I get it. If this was for non-payment of rent, it would be a different story. It's not fair for a judge, and it might very well be overwhelming evidence. I don't know. It could be. I think I did preside over the preliminary exam, I think. But maybe it was a waiver. I don't remember. But now they had a competency exam, I think. So I'm just going to put it out again. I'm sorry. Give me a date 3 weeks out. We're going to give it August. Is it the 3rd, Jennifer?
3rd at 1 o'clock.
At 1 o'clock. If you feel that strongly and you want to write a brief and tell me why I'm wrong, I'll be glad to review it. I am not always right every time, but I just cannot, under these circumstances, enter a default judgment when his failure to appear is based on the fact that he's in custody and the county didn't put him out there. Just can't do it.
Your Honor, if we serve him with this notice while he's in custody, would you entertain a default judgment the next hearing?
Serve him with what notice?
Notice to appear for August 3rd at 1 p.m.
How can I, in this case, for a termination of tenancy, I can't do that. If you think I'm wrong, you can file a brief and I'll be glad to listen to you. Read it, think about it. But I just can't imagine me changing my mind on this. This is not right. And I'm not saying that I feel sorry for him in the least, especially if he's convicted of a felony. But
a violent felony involving his neighbors, the allegation.
I know, but wait a minute, Mr. Levine. You and I always get along good, but there is this thing, as you know, there's this thing called the presumption of innocence. This is the United States of America. They have to prove the case beyond a reasonable doubt, and maybe they can prove it beyond any doubt whatsoever. But I can't just just make the assumption because there was a charge levied that he's guilty. I mean, geez, if I do that, you should even want me off the bench.
I'm not asking you for a guilty conviction, Your Honor. I'm just asking for the civil judgment, and it's a different burden of proof. It's a civil, it's preponderance. Oh, thank you. Well, I had to ask, and I appreciate you.
Thanks a lot.
We'll see you on the 3rd, 1 p.m.
Thank you.
Yeah.
Excellent Repair LLC versus Waymo Freightliner LLC. Do I have Excellent Repair LLC here?
Yes, sir.
Are you guys opponents? Oh, you're both for Excellent Repair. Okay. Where's Waymo Freight LLC? Your name, sir? You got to spell it for me. Will you do that, please?
MOHAMMEE.
And your last name, more important.
ALALYAWI.
Okay, thank you. And ma'am, what is your name?
Signal Garage.
Can you?
YFARAJ.
Thank you. Jennifer, was there proper service here?
Your Honor, it was served by certified mail. Should be printed and attached to your packet.
Well, somebody signed on behalf of the company at 419 Cedar Avenue South in Minneapolis, Minnesota. Who's the principal of this? You both or what?
That's fine.
Oh,
We're both partners, and
well, then I'm going to ask you both to raise your right hands. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got, sir?
yes.
Ma'am? Okay, so what happened here? Who wants to tell me?
So this is a customer that we usually do work for every now and then. He's not from here, he's from Minneapolis. He has a fleet of, I don't know, multiple trucks, and he always comes to us, and we always fix his units. So he called us, he was all the way in Monroe, Michigan. He said my truck was overheated. One of my guys went and did a road service for him. The water pump was leaking everywhere.
You did work to the tune of $3,127.10, right?
That was before that. That was, that's how it all started. I was talking, in this case, 3,000. Yes, that was in the shop, but before that, we went and did a road service for him. And we changed the water pump, but the actual water.
He didn't show up. They didn't show up. Listen, did you bill them $3,127.10?
Yeah, we fixed his truck. He took his truck and he left. He didn't pay the bill.
Yeah, that's terrible.
We contacted the driver, and the driver said he told me he paid. If you have an issue with him, I have an issue with him too. He's not paying me either.
Great.
So
Jennifer, give me a judgment. You're going to get a judgment here for $3,127.10 plus. You have a $70 filing fee plus. You have a certified copy charge of $12. So that's $82. So that should be $32.09.10. Do you have any other out-of-pocket costs? Why don't you guys wait around? Jennifer, will you prepare that judgment?
I'm typing it now.
$3,127.10. And then $82 in filing and service fees for a total of $32.09.10. Wait around. I'll sign it. As soon as she brings it down, I'll have my court officer bring it down. And then you're going to be all set and take that copy of the judgment. I'm sorry you're going to have to go through that.
Thank you so much.
Have a good day and good luck to you both. All right. What else do I have? Okay, counsel, I'm going to call that Midland Credit versus Lynette A. Cloud, 2601416. Good morning, Mr. Cicchini. Your name?
Good morning, Your Honor. Philippe Cicchini on behalf of the plaintiff Midland Credit.
I'm sorry, I'm mispronouncing your name, aren't I?
It's fine, Your Honor. People have been doing it my whole life. You are completely free and clear of any of any guilty feelings. You're fine.
Apologize. What'd you find out about Lynette Cloud?
Your Honor, thank you for giving us the time to do a little research. So yes, we found on the process server's website that the following comment was entered by the process server. This is Ranco Rancilio is the process server in this case, Your Honor. The note that the process server entered was, please note, server reported threat at this address after first attempt. We will not be sending anyone back to this address. We will be attempting via certified restricted mail. And then there's the following note on 4/19 at 12:39 p.m. No answer at the door. There's a car in the driveway, left notice. The process server then noted.
Wait, give me 1 second. Hang on.
Yes, Your Honor.
I'm
Yes.
going to take this right good. You do my good.
Yeah.
All right, go ahead.
Okay, and then the process server left the following annotation. I received a telephone call from a male extremely threatening from a number 313-622-5897. Just a side note, Your Honor, I did go into the defendant's account. That number does match up with a phone number we do have for Lynette Cloud. So again, resuming the note here, I received a telephone call from the male extremely threatening. He told me to stay the F away and threatened bodily harm if I return. I wasn't certain who it was, so I sent him a text and I told him in the text that you asked me to stay away, but I don't even know who this is because you didn't tell me your name or address. So he sent me that information, and that is how I knew it was for this defendant at this address.
When does the summons expire?
Oh, okay. Let me see if I have that, Your Honor. I'm sorry. We're having technical issues where I can't pull up PDFs right now. Let me see if I have that information.
Oh, I see it on the notes here. It says expires September 4. I'll grant your motion. Send your order in again. If we do we have it? Do we need him to do that again?
Judge, we should have it in pending, waiting for this hearing. So
I'm
I'm
going to go ahead
checking
and
right
sign it. And if Jennifer, follow up on that with me, please. Make sure I sign that. If we need more information, not more information, but if we need another order, we'll contact you. Otherwise, I'll sign that one.
Okay.
Okay?
Appreciate it, Your Honor. Thank you. Have a great day.
I see what happened now.
Okay.
I didn't have that information available to me.
For Your Honor, just for my information, so are you this was a hearing that was scheduled for this morning at 8:30, is that correct, Your Honor? Is it, or the clerk, if someone can?
Yes, Your
confirm
Honor. Yes, it was scheduled for 8:30. We mailed notice to your office on that.
Called you, Your Honor. You just got the motion, Mr.
Sorry, Your Honor.
Appreciate it. Okay,
Good
yeah,
day.
we'll look into it, why this was missed by any counselor or hearing counsel this morning. Obviously, we don't want that to happen in the future, so we'll look into why this was missed. So our apologies for that one, Your Honor.
No problem. Thank you.
Okay. Thank you. Have a great day.
Jefferson Capital versus Joe Tostage, 2600218.
Good morning, Your Honor. Sazan Barda, P 65425 on behalf of the plaintiff Jefferson Capital.
Is Mr. Tostage here, Jennifer?
I don't have Mr. Tostage or his counsel.
Guys, you can go right down the hall. I signed that. Thank you. He's not, the lawyer isn't here?
No, Your Honor. I'm showing Mr. Langston as defendant's attorney on that.
What do you want me to do, Mr. Barda?
Your Honor, today's the date time set for a motion for summary disposition. I will say that I have hundreds of files with this third-party debt consolidation firm who hires Mr. Langston. He has never opposed any motion out of the hundreds that we filed. If our motion is granted and a judgment enters, that's not going to stop this from resolving with the debt consolidation firm, who is actively contacting our office, and we've had numerous conversations with. So today, plaintiff is respectfully requesting that our motion for summary disposition move forward.
Grant your motion. I'm going to go ahead and grant your motion for summary disposition. There's no genuine issue. It's any material fact. You're entitled to it pursuant to MCR 2.116 C9 and 10. Just give me the breakdown, if you would, Mr. Barda, please.
Yes, I'm pulling up the motion here. I just want to make
Take your
sure that
time.
it was attached. I don't think it was attached, so I will have to submit an order for entry, and so the court.
I've got it's 357560. Got a filing fee of 75. You got a service fee of 41040, and you also have the statutory attorney fee coming up 75.
We do not charge the statutory attorney fee. We do charge the $20 motion for summary disposition fee.
So you've got
Your Honor, I'm sorry. I walked away from my computer to give that copy and Mr. Langston has logged in.
Oh,
Mr.
perfect.
Langston, your name?
Good morning, Your Honor. Matthew Langston.
He's argued his motion essentially.
And we have no opposition to their motion, so.
I'm going to grant the motion. He's entitled to principal sum of 3575.60. He's got 11604, 13604 in court costs. It should be 3711.64. Is that true?
That's true.
That sounds correct to me as well.
All right. Judgment will enter in that amount. I'll ask you to send that over, Mr. Barta. You two have a good day. Thank you,
Your Honor.
Thank you.
Do I have J&B Medical Supply? Jeez. Versus Deanna McLean?
Yes. Christina Codrington for the plaintiff.
Good morning, counsel. How are you?
I'm good. How are you?
Ms. McLean, your name, ma'am?
Hi, Deanna McLean.
Any resolution on this?
The account's been paid in full. Our office is filing dismissal.
Your office is going to file a dismissal?
Correct.
Did she pay in full?
Yes.
So you're going to submit a stipend order to dismiss?
Yes.
With prejudice, correct?
Yes.
So you understand and agree to that, ma'am?
Yes.
I mean, it's in your benefit, and she has your permission to sign your name to that document?
She's already signed it herself.
Oh, perfect. All right, send it over. Have a good day, everybody. Keep
Thank
smiling.
you.
Good luck. Thank you.
Thank you.
What'd you tell me again about Aloha?
I believe he may be in the courtroom. He was a Samsung device we couldn't connect with. So he was going to come here to the courthouse.
Aloha?
Mr. Sings.
Come on up here, sir.
To the podium.
2601776R. Your name, sir?
Samsi Idemi.
Nobody showed for defendants, right?
No, Your Honor.
Did they file an answer to the complaint?
Yeah, they've got to say yes.
I don't know why they didn't show up. There might be a valid reason and there might not. Defendants failed to appear. This is a pretrial. Defendants failed to appear. Default judgment will enter. I'm going to give you the following amount. You prayed for it and you are entitled to $4,075 in a principal sum. And then you had court costs. You had $110 in filing and certified fees. So 70 filing, two charges for certified mailing, 18 and 12. So you have court costs there in the amount of 100. Plus, I think that's it, isn't it, Jennifer? So I'm gonna enter a judgment amount of $4,175 in your favor and against the defendants. They were supposed to be here at 8:30. I know you had a problem with your device. You couldn't connect, and so we told you to come in. You're here. They're not. You win. We'll send the judgment out to you, okay?
Thank you, sir.
I wish you well. Good luck. Thanks. Is that it?
We have a defendant on Zoom who lives in Detroit. She has 3 warrants and she wants to be here.
She can't make it here? Well, she's gonna have to make it here. Who do we have on?
Her name is Ashley Stevens. She's in Zoom. She said she has no transportation from
Where's
Detroit.
she live?
She's in Detroit, she said, Your Honor.
How old are the cases?
2022.
Oh, well, hey, if you can't find a time to get here, she's gonna have to show up. Give me a break. She's got 3 warrants from 2022. Come on. Tell her the judge said she has to appear in person. And if she doesn't, the warrants are going to remain in full force and effect. Thanks.
You're welcome.
Against Alex Richard Sobolak, file number 25 W840292.
Michael Lee Carmen, P7324, but at the front of your honor.
Your name, sir?
Yeah.
Alex Richard Sobolak.
Okay. You're not just in custody. Well, no, he's not in custody on this at all.
No.
All right, I'm gonna go ahead and adjourn it. We'll adjourn it 2 weeks, okay, Heather?
Okay, Judge, so we either have, because of this add-on docket, we have the 22nd or August 5th for Woodhaven.
Make it July 22nd at 8:30, okay? Or you want me to make it later because it's in custody, and maybe I'll make it 9:15, okay?
That would work, good, Judge.
9:15. 9:15. Sir, good luck to you. We'll see you here then. Thank you. People against Sorrell. Gregory and Lynn Sorrell, 26W842 674 26W842997. And that's it.
Michael Lee Carmen, P7324, but at the front of your honor.
Mr. Sorrell, your name, sir?
Gregory L. Sorrell.
Good afternoon, Mr. Sorrell. Does he stand mute, waive formal reading on these?
Yes, sir, on both matters.
Not guilty pleas are entered, and now, as I understand, he's going to plead on. I can't read the. Looks like he's going to plead on this case, May 27 incident. He's going to plead his charge to trespassing, and then they're going to go ahead and dismiss 6W842997, right?
Correct, Your Honor.
Is that what you want to do, sir?
Yes, and I want to explain about, I was in jail on my birthday already, and I've been here 30 days almost already, sir, so I think I should be able to get out the 18th this Saturday, which was planned on.
If you plead guilty to the trespass charge, the possible penalties are up to 500 fines, 90 days jail, costs are all those. If you plead on that on 2874, offense date May 27 to 26, I'll go ahead and dismiss on motion of the prosecutor the May 24, 26 incident. Do you understand that?
Yeah, I understand that.
Understand you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or jury. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights. You'll be giving up the presumption of innocence, waiving the requirement that they prove you guilty beyond a reasonable doubt, your right to a trial by court or jury, right to question witnesses at that trial, and right to bring in your own witnesses. Do you understand that?
Yeah.
To the charge trespassing from May 27 to 26, how do you plead?
Guilty.
Were you at 22470 Allen Road in Woodhaven at Super Suds?
Yes.
Had you been told that they did not want you there, or had been trespassed from the property by either signage or letters or communication from the owner?
Yes.
And you went back anyway, right?
Raining and snowing, yeah, and had to use their facilities to dry my clothes and spend money there, yeah. There you go.
Right now, are you on probation or parole?
No, nothing.
Anybody force you to plead guilty?
No.
Please accept it to that charge. I'm going to dismiss on motion prosecutor 26W842-997. Heather, can you pull up Mr. Sorrell? I'm not sure when I sentenced him on the last case.
Let me take a look here, Judge. I want to say it was 45 days.
I gave him 45, starting when?
Yes. It was, I believe that was the 17th of June.
So he served 14, he served 27 days, including today, it sounds like, right?
I just want to double check. I'm going off. I just got to find the correct. I'm almost positive, Judge, that that's correct. I just want to make sure I haven't hit all the right cases here. Sorry.
And can you give me the case number of that one?
Yep, that one's 26W 843401. So yes, it was 45 days beginning June 17th.
Anything you'd like to say, Mr. Carmen?
Yeah, I would ask for consideration of an immediate sentence and credit for time served, please.
Anything else, Mr. Sorrell?
Yes, sir. I told you what's up. I'm getting $1,200 Social Security when I get out of here, and for sure, and I'm getting out of Woodhaven. I'm buying a place in Taylor. So
You told me that
you know what
stuff
I mean?
for 5 years now.
What? I mean, I'm doing it. See, you never give me a chance anyway. You don't give me. You don't give. Here's what's up. You never give me personal bond ever either. Never. One time. That's it.
Mr.
You
Sorrell,
don't even give me a chance.
Mr. Sorrell,
You don't.
I don't know what's going on with you.
I know
You're
what's
in front-
going on. I'm getting out of town. I am. You can't. You know what? See, you won't even take a chance on it. I need to get out of here, man. Saturday, I was supposed to leave, man. So
You've been
So I
coming
really
in
don't.
front of me and Judge Hessen repeatedly over the
I
course of the
know.
last
I
3
know.
4
You
years.
won't give me a chance right now. I told you what's up. I get $1,200 coming, and I got buddies that are going to help me too with vehicles for the time. I'm buying a vehicle anyway, so I can get my Social Security in 1 month. Oh man.
100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 325 or 7 days. I'll give you credit for time served on that case, 26W843401. You'll serve out your jail term on the other and be released. I just don't understand why you won't stop trespassing.
What did you give me? 7 days then?
No, you're all set on this one. You just have to finish out your jail term on the other one.
Oh,
Good
and
luck.
I'm done, right? Saturday,
Good luck.
I'm done then.
Good luck.
Saturday,
Thanks.
I'm done, right?
Okay.
Right, I'm done Saturday. Then I can walk out of here. That's the day I'm supposed to walk out. The 18th. Yeah.
If that's what they told you, I gave
Okay,
you
good.
45 days.
Okay, good. That's what they told me. You gave me a chance this time. You watch. I will prove to you, man. And all I do is witness for Jesus. That's why I'm back in here anyway. There you go.
All right.
Yeah,
Good luck, sir. Salitha Chanel Wilson Tallison, 26W841681. Your name? When did you get here today?
Okay. The name is 2 to 150. That I was trying to explain to you what happened. My mother called me, just told me my uncle was rushed to the hospital with blood pressure 700 and sugar 15.
Slow down. I can adjourn this for you. You want me to adjourn it?
Yeah.
You live in Woodhaven, right? All right, I'll just go ahead and adjourn it. I don't think I've ever said ever arraigned her, right, Heather?
That's correct, Judge.
Just adjourn it. You set a date. Go down the hall. They'll give you your date, okay? When you go to the hospital. I'm sorry for that. Good luck. Donahue. Go right down and talk to those ladies. Daniel Ryan Donahue, file number 6W841850.
Michael Lee Carmen, P7384, on behalf of the defendant, Your Honor.
Your name?
Daniel Ryan.
All right, so what are we doing on this one? He wants an adjournment, right?
First card.
Is that right, sir? You want that?
Yeah, sure.
All right, first of all, let me give you a $500 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed, okay? So I'm giving you a personal bond on this, but there are bond conditions. No contact with prosecution witnesses. You're not to enter 23800 Allen Road or any other wall marked. You're not to enter 23800 Allen Road in Woodhaven or any other wall marked. $500 personal bond. You cannot leave the state. You cannot violate a law. You must appear in court as directed. You have to go over to the Woodhaven Police Department to be fingerprinted and photographed today by 3:30. Any reason you can't get there by 3:30?
No, I'll go there as soon as I leave here.
All right, so you have to go over to the Woodhaven Police Department to get fingerprinted and photographed. I'll give you a new pretrial date, and that will be when?
We could do July 22nd at 9:45.
July 22nd at 9:45. If you want a court-appointed lawyer going forward, you're gonna have to fill out a petition for one, okay? Do you work?
Yes.
Where?
I just started my own tree service 2 months ago. I've been doing tree work for 7 years, but I finally went out and bought my own equipment, so.
But wait a minute. You did my tree once.
Correct.
And then you were in front of me on that other case and you
Yes,
didn't
sir.
show up on it.
Years ago, yes,
So that's why I thought,
with you had put me in drug court, sobriety court.
and you didn't show up.
Yeah, and there's issues before in the past, but I'm on probation with passing. I can't say, Your Honor, I've changed my life around. I'm doing great for myself and.
Doesn't look like you're doing too great. You keep getting yourself in trouble. If this is doing great and you turned your life around, I'd hate to see what happened if you didn't turn your life around. You still got a warrant out of Southgate, out of Detroit, out of Southgate, out of Lincoln Park, and out of Monroe. So 2 out of Southgate, Monroe, Lincoln Park, and Detroit. Go take care of those before you come back.
Okay.
Fill out a petition for court-appointed lawyer. We'll see you here. Good luck. Destiny Henry. Make sure you go over there and get fingerprinted. I filled out the order, Heather. Destiny Danier Henry, 26W842495.
Michael, the comment B73824, I'm gonna have to defend Your Honor.
Your name?
Destiny Henry?
She's gonna plead to disturb the peace under HIDA. Is that right, ma'am?
Yes.
And then we're gonna go ahead and dismiss the stalking. If you plead to that under HIDA, I'll set terms and conditions. If you're compliant by, when you come back, the case will be dismissed on motion, prosecutor, and they're saying, possible proof issues, justify reduction, including HIDA. So, do you understand everything here? If you plead guilty, the possible penalties under this, for disturb the peace under HIDA are up to 500 fines, 90 days jail, costs, or all those. And then I'll dismiss the stalking. Do you understand?
Yes.
Did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that? You got to keep your voice up.
Yes, sir.
All right. Is this how you wish to proceed? To the charge disturb the peace, how do you plead?
Yep.
On March 16 and 26 at 3:22 p.m., were you on Montebello near Albert and Woodhaven? You weren't on Montebello Drive near Albert Street in Woodhaven?
No, sir, I don't have a car to get out.
Where were you?
Home, probably.
Oh, wait a
I
minute.
believe that's the address. I believe the address in question was where the complaining witness was located.
Okay.
This is involving sending, receiving text messages.
Okay. Okay. So what did you do? What kind of messages did you send? Did you threaten her?
No threatening messages. We're currently in a custody dispute. Judge Heston signed an order to give my son back. They didn't give my son back, and for 52 days they kept him from me. And it was just 52 days of being angry. But
So you're angry with, this is the mother of your child too?
the mother of my son's dad, my son's parent.
I see.
Yes.
So she's the one you were alleged to be stalking?
Yes.
And what did you send her when you were stalking supposedly? What kind of text messages? What kind of phone calls?
No phone calls, all text messages, but they were, my son's dad had been lying throughout the.
I just want to know specifically what you said, ma'am. I have to believe you're guilty of something. So tell me what you did.
There were multiple messages over a span of.
Great, I heard you. Now tell me what you said in the messages.
There's nothing specific, I just called her a bad person, I said that this.
You're a bad person, that's what you put on the text? Yes?
Yes.
So I won't see anything more than you're a bad person?
I mean, I went into the situation, I listed out the lies, I listed out.
Swear at her? Did you call her names?
I don't think I was name calling until the end.
Well, at the end, were you name calling?
I think I did call her.
What'd you call her?
I'm sorry, little bitch, on my son's second birthday.
And you texted her how many times, say, within the week preceding that?
Oh, I don't think, it wasn't. It was the time that the one time that I called her out of her name was my son's second birthday, but it wasn't like, I wasn't texting every day. It was just like,
Can you help? Feel like,
Sounded like everything like
yes.
Ms. Henry, you said this solely dealt with text messages to this complainant, correct?
Yes.
So you started off sending her a couple, correct? And at any point did she tell you to stop communicating with her?
probably around March 16th.
And
After March 16th, did you continue to send her unwanted text messages?
Yeah.
And did the police have to become involved as a result?
Yes.
Okay, so the police had to become involved because you're charged with a crime. That's fine.
are you on probation or parole?
I'm Judge Huskins.
Were you on probation or parole at the time that this offense occurred? Back on March the 16th?
Yes.
You understand if you plead guilty here and you were on probation on March 16th, that this case would be deemed a violation of that probation could be revoked. You could be incarcerated as a result of this plea and conviction. You understand that? I can't hear you, ma'am. Anybody, you still wish to plead guilty?
Yes.
Yeah, all right. Nobody's forced you to plead guilty? All right, I'm gonna accept your plea to that charge. I'm gonna order a pre-sentence report. I'm gonna give you a sentencing date, and I'll take it under HIDA, September 22 at 8:30. July 22 at 8:30. I'm sorry, July 22 at 8:30. Go get your notice and you're all set, okay? And you can leave, but before then, you have to talk to probation today, okay? Good luck.
Thank you, Your Honor.
Cameron, thank you. Cameron Thomas Brad, 26W843536. And I also have 26W843531. Your name?
My name is Cameron Thomas.
They're going to dismiss the littering. You're going to plead to the civil infraction of pedestrian violation, right?
Yes, that's correct.
Jaywalking on Rygate near Heritage Drive.
That's what.
To that charge, responsible or not responsible, pedestrian violation.
Oh, responsible.
I'll accept the plea. Fines cost of 75. Littering's dismissed. You're all set.
I have just one question for you.
Sure.
I actually heard that you may know somebody that was related to me, my grandmother. Her name is Jean Brad.
Yeah, but I can't do anything for you.
Yeah, I know. I wasn't asking you to do anything about that. I just heard, just wanted to say.
I mean,
she was a big part of my life, so I was just wondering.
Yeah.
He actually wanted to know if you knew Richard Brad or Audrey Brad, which one you knew more. And I thought it was my mother, Audrey, because of the dry cleaners, but I'm not sure.
No. Where did Audrey Brad live at?
She used to live at 2211 Medford Street. Right here.
Yeah, right on the corner of Medford and Harrison.
Yeah.
I mean, I haven't seen her in decades. They had a big sign up for me when I ran when I was a kid. I was a kid then.
She actually passed away in 2023.
I'm sorry about that.
Yeah, she was one.
Are you gonna stay out of trouble?
I'm trying to get myself a job right now.
What, did you graduate?
Yes, I graduated with a diploma.
When's the last time you worked?
Friday. Actually, I lost my job Friday.
How'd you lose your job?
I was about to go do some comments that were made about another associate. Because they were
About what?
another coworker of mine was harassing me, and I just made some comments under my breath, and then my boss asked me what I said, and I said it again.
Where were you working?
It's like with Walmart.
Where?
Walmart, right over there on 20.
The lawyer wanted the judge to issue a default judgment immediately, but the judge refused. And what happened next reminded everyone that the justice system works differently than many people think. The hearing centered on a neighborhood dispute that had already turned into a criminal case. According to the allegations, a man had attacked his neighbor with a baseball bat and was now sitting in jail while the civil eviction case moved forward. The plaintiff's attorney had a simple request. Since the defendant wasn't appearing in court, he asked the judge to enter a default judgment immediately. From the attorney's perspective, the case seemed obvious, but the judge saw a much bigger issue. He explained that the defendant wasn't skipping court by choice. He was already in custody, and the jail had failed to produce him for the hearing. punishing someone for not appearing when they were locked up simply wasn't fair. The attorney argued back. He reminded the